Thank you, Bill. Good afternoon, everybody. This is Ricky Adams. I'm the Vice Chair for the Estates and Trust Study Group. I'm pleased to welcome our speaker today, the Honorable Byron E. McFarland, the Register of Wills for Howard County. He's going to be presenting Coping with COVID-19, Planning for Progress. And just to speak a little bit about his background, he's been the Register of Wills since 2010. And from 2013 to 2016, he served as president of the Maryland Register of Wills Association. Now, before he gets started, I did want to mention we're going to be doing questions after his presentation. You can submit questions via email to angela@msba.org, or you can also enter them into the YouTube chat box in front of you. Now, this presentation will be recorded and available later for your viewing pleasure. It's actually our last presentation for the season. So we're delighted to have Register McFarland with us, and I'm going to turn it over to him. Thank you.
Byron, you are muted.
There we go. Well, thank you, Ricky and Micah and everyone at the Bar Association for putting this together and for inviting me to speak. It's been a challenging couple of months, but what I'd like to talk to everyone about today is not only how the registers and to some extent the Orphans Courts have coped with this pandemic, but also some of the things that I and some of my colleagues are working on going forward, because one of the interesting things about this whole situation that we're dealing with right now, it's funny, I hear a lot of people out in the community who are frustrated about the shutdown and how difficult it's been for them, that people in government are sort of, they're enjoying the power of, keeping people at home and shutting things down and all these parameters. And I can tell you, not a single person I know in public office ran to deal with this pandemic. We ran to try to help people. And so what's really important is, number one, that we, deal with this pandemic and do it safely. Number two, I think that we learned some lessons from what we found during this time, but also keep moving forward on some of the things that we know are pressing and things that we can do to continue to reform the probate process in Maryland, something that I've been working on since day one, and I've never really stopped. So that's what I want to talk about today. So I'll just go ahead and get started here. So as all of you know, so there are 24 registers. Each of us have different options and challenges with our offices for a variety of reasons, and I just want to cover them briefly. First is our location. We've gotten our, sort of big picture instructions from Chief Judge Barbera, but of course it's up to each circuit court administrative judge and district court administrative judge to make decisions on how they're going to operate their courthouses. So it's been a little bit of a challenge as we, each of us, we've got one chief judge of the Court of Appeals, but we each have different administrative judges. And we've got, 4 of our registers are now not in courthouses anymore. They're in county buildings. So, those registers have really had to follow guidance from their county governments, which are really following guidance from the governor. So that's been a little tricky. As far as staffing goes, I think as soon as the pandemic started, a lot of us went to some kind of alternating staff schedule so that we could sort of reduce the exposure of our staff to potentially getting sick. Some of the offices had the technological ability to go entirely remote. I think Montgomery County is one that sort of had the existing tech infrastructure that all of their employees could go work from home pretty much right away. And some of us have had to take into consideration, I think just as many of you have, for yourself and your firm and your families, people who work for us who are in an at-risk population. So anyone who has an underlying health issue, anyone who lives with someone who has an underlying health issue, and people who are, in a certain age range that has been identified as being at risk. So we've had to make sure those employees of ours, feel safe and that they, can continue to work, but also do so in a safe way. Also our caseload, as you know, some of our jurisdictions open fewer than 10 estates a week, and some, my colleague Grace Connolly in Baltimore County, as she loves to tell everyone, has the most cases of anyone in Maryland. So she opens over 100 estates a week. So it's a little bit more imperative for her and her staff to be there and to continue to process paperwork so it doesn't pile up and so that the public is being served efficiently. Next slide, please. As I said, our technological capabilities vary somewhat. Any one of you who's been in multiple registrar's offices know that we have same computers, the same printers, the same scanners for the most part, and we use the same software, of course, but not every office has work laptops or cell phones that our employees can take home, and not all of our employees are familiar with teleworking. For a lot of folks, they've been, their working life has been coming to the office and answering phones and being physically in the office. So that's also been a hurdle. For the Orphans Courts, many of the Orphans Courts, here in their courthouses, some only have one computer, so that's a challenge for them. Some don't have any. In some jurisdictions, the Orphans Court, they rely on the registrar or a registrar's deputy to help them through everything during their hearings, to write orders, etc. So that's a limitation on the courts. And some of the judges obviously also don't have, just like our staff, they don't have the equipment or the familiarity with equipment to work remotely. So I think in a lot of jurisdictions, judges have, to their credit, continued to come in for brief periods of time, once a week, twice a week, once a month, depending on their existing schedule and caseload, to sign orders and deal with matters that the registrars put before them. Next slide, please. Also, acceptance of papers. I was very happy that at the beginning of this pandemic, the Attorney General's office and the judiciary gave us the permission to begin accepting filings by email and fax. Now, many of you know that we accept sort of extensions by fax or supporting documentation for an account by fax, but we've been able to take accounts, petitions, you name it, over email, which has been really wonderful. And a lot of us have been accepting electronic signatures. I know, for my office, you can email us anything but the original will, essentially, that you need to either mail to us or drop off at the office. Something that we can all do that many of you may not be aware of is that we can create invoices that can be paid online for anything. And we generally only generate invoices for non-probate inheritance taxes. But if you have a $500 probate fee, for example, if you call the office and talk to someone, we have the ability to create an invoice for you. We can give you the invoice number, and you can pay that online with a credit card. So that's something we've been doing to try to expedite the process and cut down on people having to mail checks. Some of us have installed drop boxes. We have one at the front of our courthouse. We've had folks call who want to file their wills for safekeeping, but they don't feel comfortable mailing them. So that's something we've been doing. And I know I've heard from a lot of folks that we have not been uniform on all of these things. So whether it's accepting filings by email, accepting electronic signatures, invoicing, drop boxes, all those things. I know we haven't been uniform, but I think each registrar is just trying to do the best they can. And also, two of us, Howard and Montgomery counties, we have a live chat feature on our websites now, which has been wonderful. I noticed early on that Montgomery County had done this, so I contacted my colleague, Joe Griffin, and we were able to set up the same system for Howard County. And it's really wonderful because whether you're an attorney or a layperson, just whether you have a quick question to ask or a long question to ask, rather than calling us or emailing us or putting something in the mail, you can chat with one of us right away, and our employees' names actually show up right on the screen, so you're talking to someone who's actually here in the office, not some sort of automated service or anything. You're talking to a skilled, experienced staff member who can help you. Okay, next screen, please. So as I said, in most jurisdictions, judges have been coming in periodically to sign orders. Very few hearings have been held. Up until now, the Court of Appeals had ruled that we could only hold emergency hearings. And that's something that I think that the registrars talked with the Attorney General's office and the judges about, which is sort of like, what exactly is an emergency hearing in probate? And thankfully, we haven't had anything here in Howard County, at least, that we deem to be an emergency. And thankfully, we also have all of our judges have the technological capability to work remotely. So, yesterday was our court day, for example. And each of the judges, they were on a conference call. We sent them all of the things that they were before them for the week in advance. And by the close of business, they had all told us what to put their names on and what to send out. So that's worked really well. And now we're exploring platforms for remote hearings for regular matters. And I've been working with my court to try to use, we're going to be using Cisco WebEx, which I'm told is what the Court of Appeals is going to be using. But that's what we're going to try to use to try to especially deal with a backlog of cases that have been held up since March and April that really are pressing. I mean, we have show cause hearings back from April that we really need to try to dispose of as soon as possible. Okay, next slide. So that is sort of a, I'm sorry, one more slide on coping with COVID. So as I said earlier, each of our courthouses is going to be doing things a little bit differently in terms of screening members of the public. Right now in Howard County, for example, face masks are required, social distancing is required, and the sheriff's office is doing a brief questionnaire for members of the public who are coming in, and both for members of the public and for staff, including me, they are doing a contactless temperature check to see if anyone has a fever. And I'm told as of the end of last week that we haven't had to turn anyone away yet, so that's a good thing. All of our offices are in the process of procuring PPE, plexiglass screens for our desks, as I'm sure you've seen at all kinds of retail locations, Starbucks, wherever you go, hand sanitizer, disinfectant, etc. And that's all in preparation of having a greater staff presence back here, but also having members of the public coming in. It's likely that we're going to have in-person availability for the public to come in soon. A lot of the registers and I are keen on the idea of having an appointment-only kind of system for a little while. And the reason for that is, you may have someone, and I think that these days, most people, I think, regardless of how much things reopen, are going to be a little bit more thoughtful about, when they leave the house, why they're leaving, how long they're going to be away, and how many people they may come in contact with while they're away from home. So if we can tell, John Smith, member of the public, you've got an appointment at 10 o'clock and we only have one appointment at a time here, so you're going to be the only member of the public here, and we're only going to have 3 staff members here, something like that. It might give some reassurance to that individual. They're not going to have to wait. They have a set appointment time, and they're not going to be in sort of a, not everyone knows what our offices look like. So if people have sort of apprehension thinking about one of our offices being like a crowded, like MBA location or something, that's not what they'll find. What they'll find is that they have not a lot of people around them. They've got privacy, and their time is going to be respected. So those are some of the things we've done to cope with this pandemic, but also, sort of plan to slowly reopen in accordance with the judiciary's 5-step plan. Next slide, please. I just want to recap a couple of things that are relatively new additions to our operations. One is that all of our claims are searchable now on the Register of Wills website. So if you're looking for claims against a decedent and you don't know necessarily where they may have been filed, maybe they lived in Anne Arundel County all their life, but then they spent the last few years of their life in Howard County under medical care, instead of having to call 2 different registers, you can just go online, and just like our estate search tool, you can search for claims, and it'll bring up any claims against a decedent filed anywhere in the state. So we have that now available. We also have all of our legal notices searchable and viewable on our website. So that sort of gets to our proposal to do something about our onerous publication requirement that I'll get to in a little while. But this is sort of a precursor to trying to minimize or get rid of our print publication notices by allowing all of this to be on our website for free. And another thing, and each office is handling this a little bit differently, but all of us have access to records for wills for safekeeping statewide. Now, this is something not available to the public, obviously, and in each office, there are only certain employees who have access to this. But I'll just say, like in my office, every single one of my deputies has access to this. So whoever you call and you get a hold of, if you say, I'm looking for the will for Jane Smith, we can look not only in our own safekeeping records, but we can look statewide, and that'll help you avoid the time of having to call multiple offices. And lastly, there was one piece of legislation that the legislature approved that was signed into law by the governor before the end of their abbreviated session this year, which was creating a more streamlined process for disposing of after discovered checks up to $1,000. So we're developing a form for that we hope we'll have ready by hopefully in advance of October 1st when this law goes into effect. Okay, next slide, please. So I've got a couple slides here where I want to talk about an issue that I've taken a lot of interest in, which is nominal bonds. And the one after that is going to be our publication requirement. And I want to kind of preface this conversation with this, which is that, we have tried to work over time to make probate, especially for small estates, as easy as possible for all of you as practitioners, but also for the public. There are two aspects of opening most estates that we have no control over, which are the requirement for nominal bonds and the requirement for publishing notice in the newspaper. Both of these put us, put you, put the public sort of at the mercy of an ever-changing, ever-evolving private sector market for bonds and for legal notices. And it's sort of frustrating because these are things that we've got to tell people, and you've got to do it too. All of you know, you've always had, a client who, comes to you who says that they went to open an estate and their father's will waives bond, but the register said I need one anyway. It is an obnoxious, time-consuming, frustrating thing to have to explain over and over and over again when people think they don't need it. And the publication requirement, I think people sort of understand why, but as I get into later, I don't think that it really provides much benefit at all, if any. So with that, I want to start on nominal bonds. So what I have been talking to folks about for a year and a half now is the idea that we would eliminate the necessity of obtaining a nominal bond if the will excuses bond or all heirs consent, which is in 99% of estates that qualify. We rarely need to surcharge a bond to pay probate fees, claims, or taxes. And my idea is that we would only require, or there would only be a nominal bond required if there's a substantial claim against the estate or there's an inheritance tax liability. Now, one of the things that I do, and I know a lot of my colleagues do, is we try to negotiate with you and with members of the public to try to prepay inheritance taxes so you don't have to get a larger bond. And that's something that we would continue. Next slide, please. As I said, we're sort of at the mercy of the private sector in Howard County. I remember when I took office, the staff that were here showed me a list of all the bonding agencies in Howard County. And over time, many of those have discontinued their practice of issuing nominal bonds, and we're down to one agency, and it's a family-run business. They have told us it's not really super profitable for them. So all it would take is this family business changing ownership or changing policy or closing for Howard County citizens to have to, if they want to get a bond right away, to have to travel to another jurisdiction to get the bond. Now, there are options I'm aware of where you can get a bond online. But if you want to get a printed, in-person bond right away so you can get appointed and you can get your letters of administration, we've only got one left here. And if in a place like Howard County with a population over 300,000 people, we're the 6th largest jurisdiction in Maryland, if that's where we are, I can only imagine the limitations on some of the smaller jurisdictions in the state. And as I said, we rarely have to call these bonds in. I surveyed my colleagues, and I'll get into some statewide numbers in a second, but just as an example, in fiscal year 2019 in Howard County, we had 347 estates that required a nominal bond. The company here in Howard County charges $100 for those bonds, so it's roughly $35,000 it costs the public to get them, not to mention the fact that people come to the courthouse, we get the paperwork started for them, then they've got to leave and drive to the bonding agency, they've got to come back, they've got to go through security again. And it's not, and when we move to our new courthouse in a year, it's going to be even a further distance for them to go to get their bond. Of those 347 estates, we had to surcharge one bond for $400. And it's really hard for me to justify having to explain to 346 families they've got to go through all this time and expense for such a really pathetically minimal benefit to us and to the state. And to put that in context, this year, my Office's revenue is going to be almost $4 million. So in the grand scheme of things, $400 isn't a whole lot of money. And again, obviously, the overwhelming majority of PRs pay their fees. So why require this when it's so rarely the issue that someone doesn't pay? And as you all know, the registers have other ways of collecting those fees, which is to go to central collections. And basically, as soon as we send it to collections, it's out of our hands and we'll get our money eventually. And we don't have to go through the time and hassle of getting people to get a bond. Okay, next slide, please. Now, looking broader statewide, nearly 10,000 estates, so that's about a third of our estates statewide, require a nominal bond, despite having a waiver in the will or all the heirs waiving. The total cost of that is over $1 million. And that's sort of stunning to me. It's over $1 million of people's inheritance they've got to pay to get a bond that basically serves no purpose. So again, to sort of summarize this, my proposal is that, and we would have to go to the legislature and to the rules committee to accomplish this, but if an estate does not require a bond because the will waives or heirs have waived, the registers would not have to require a nominal bond as long as there are no inheritance taxes owed. We would require a bond sufficient to satisfy taxes unless the PR pays up front, which often is the case. We would continue to require a bond if the will does not waive or the heirs don't consent or there's some sort of dispute. And that is very, very, very rare. And to put this in context, this would alleviate, if we were to adopt this proposal, this would alleviate the need for nominal bonds in over 99% of the states that currently require one. So they would be exceedingly rare, is the bottom line. And this is a huge benefit to you, to your clients, to pro se individuals who come here, and to us, frankly. Next slide, please. And just to cover one other issue, is one of my colleagues and I had a long discussion about whether, our concern is with inheritance taxes and probate fees, but what about claims that have been filed against an estate? And my colleague's perspective was that we should require a bond because these are claims of record and they're interested persons. My perspective is that, any creditor has the right under estates and trust to petition the court to increase a bond or to require a bond if they're concerned that they're not going to get paid. So my perspective, I don't represent out-of-state debt collection agencies, which are so often the claims that are filed against estates here. And I have a really hard time as a representative of the state, I'll put it that way, telling someone, well, I don't care about the wishes of your father in his will. I don't care about, or if it's an intestate estate, I don't care about you and your siblings all agreeing to this. I've got to protect DCM services in Nebraska or wherever it is, and you've got to get a bond anyway. I don't think that is my role or responsibility, and I don't think it's unreasonable to put that burden on the creditors. It's their debt. If they want to collect it, that's up to them. Just like any other interested person, it's up to them to press their concerns. And if we were to require bonds for claims, that would reduce that number of estates. We would eliminate the need for a nominal bond from 99 to 70. So it would really hack away at the benefit that we're trying to accomplish here. So I would revert back to my proposal that registers would only have to require a nominal bond if the will doesn't waive it, if the heirs don't waive, or if there is some unpaid substantial inheritance tax liability. So that is it on nominal bonds, and we'll move on to the next slide, please, and talk about publication requirements. This requirement's sort of rife with problems, and we'll start with similar to our bond issue, which is that some jurisdictions only have one newspaper. Most are not widely available. Even in a place like Howard County, I don't know if there is any newspaper, print newspaper, that most households get in our county. I think it's a minority for any publication. And I know I've lived here my whole life, and I scratch my head thinking about where I can even find the Howard County Times. I can think of only a couple of places that aren't the library. So that's an issue. The cost varies dramatically statewide. Small estates range from $10 to $114, regular from $20 to $306.90. In one jurisdiction, some of you may know this one, the publication fee is different based on how many attorneys of record are involved in the estate. And the total statewide cost is almost $1.4 million a year for the public to have to put these publications in the newspaper. There's also an issue with financial liability for us, which means the state, which means all of you, which is that some of these publications will not publish. And again, some of you are probably aware of the jurisdictions that do this. You must give a check to the register, and the register has to take custody of that check that is made out to a third party, not to us. And we are then liable for that. And we are supposed to, and the publications have said they will not publish notice until it is the register, the state, the public, that gives them that check. And I find that really untenable. And I really think that at the end of the day, there's really little to no benefit to the target audience of these notices. So next slide, please. And the reason I say that is that I, based on my own experience here as register and talking to my colleagues around the state, we had a conference, one of our last in-person conferences last year, and I asked every single one of my colleagues was in the room, and I asked this question, and again, the purpose of these notices is to reach unknown heirs and creditors. I know there are lots of folks that like reading, death notices and estate notices, just to be abreast of what's happening in their community. That's not the purpose of these notices. And I asked my colleagues, again, many of them have been doing this a lot longer than I have you ever had someone call you and say, I am, Sarah Smith, and I am an heir in my father's estate, and I was never given notice of the opening of this estate, but I read about it in the newspaper? And the answer was no. I mean, it was a deafening silence in the room. Now, are there people who call and say, oh, I found out my uncle died, I'm supposed to inherit something and I wasn't notified? Yes, but that's usually because people have heard about it from a relative or just word of mouth, not because they read it in the Cecil Whig or the PG Post or whatever it is. It's by word of mouth. It's not by looking at these printed newspaper publications. Next slide, please. And there's an issue that a colleague of ours who I have a lot of respect for brought up during a meeting where this was discussed, which was that this publication requirement is not just some sort of antiquated formality, that it actually, there's a due process aspect to it, which I understand and respect. I think that the addition of allowing all of our notices to be published online for free helps to satisfy that concern. And I think, again, if the starting point we come from is the fact that it is rare, if ever, that anyone, again, in the target audience for these notices ever reads these things in the newspaper, how are we giving them due process if they're not even seeing it? So that's my concern. And we're gonna monitor the traffic to this part of our website to see how well trafficked it is, and that's something that that will contribute to this conversation as we go forward. One other option that we've discussed is, well, instead of maybe putting 100 estate notices in the paper a week, and it's basically all the same language over and over again, putting some kind of very simple notice in a paper in every jurisdiction that would say, for all estate notices, visit our website, something like that. So there's still something in a print publication, maybe for people who don't have access to a computer or a smartphone or something like that. So that's something that we've considered as sort of a middle ground. So with that, I want to move on to fees. As most of you know, probate fees in Maryland are relatively low compared to some of our neighboring states, and many of them have not been changed in some as recently as 20 years or as long as 50 years. We have been interested in increasing the claim fee, which you know is only $3, and clarifying the controversial fee to require a higher fee for caveats, $10 or $20 to completely upend the probate of an estate, to diminish the power of a PR to a special administrator, should cost more than $20 is the bottom line. And our idea would be that we would create that fee, basically referencing the filing fee in circuit court. And for some time, we have thought about, well, just doing sort of a cost of an inflation adjustment on all of our fees, and that seemed to make sense. But I think something that we're concerned about, given the current economic climate and how many people are unemployed, et cetera, that we're maybe instead of raising fees, we will look at restructuring our fees. And something that occurred to me recently looking at our revenue and our bookkeeping is that we could eliminate small estate fees, the fees for safekeeping of wills, for copies, and for requesting additional letters. If we raised our regular estate probate fee by just 50%, actually we would be able to make up for all of that if it were less than 50%. And this way we could offer safekeeping for free for people. If you want to get copies, all of that would be publicly accessible without having to pay us anything. And we rarely have to charge people for additional letters, and it's kind of a hassle for us. I don't like nickel and diming people for that stuff. And also with our small estate fees, interestingly enough, our small estate fees in Howard County are 30% of our receipts. So 30% of the checks that we get in are for small estate fees. They come up to total revenue of 1.5% of what we bring in. So it's a lot of work to nickel and dime people. And I would love it if every time you filed a supplemental Schedule B or whatever it is, I don't have to charge you another 75 cents or whatever it is. So those are something those are some issues that we're looking at, sort of to make sure that we're generating the revenue we need to cover our cost of operating, but also with sort of a mind to equity and fairness, sort of streamlining our fee structure to make it easier for people to access our services. And I'm eager to hear some feedback on that in particular. The last two things I want to cover, and I'm trying to be mindful of time here. If we go to the next slide. The Orphans Courts. As you all know, for the past 2 years, there has been legislation proposed to study the Orphans Courts in Maryland. Maryland is the only state left in America with an Orphans Court. Delaware abolished their Orphans Courts back in the 70s, and Pennsylvania did in the last, I think, 5 or 10 years. And just like in Montgomery and Harford counties, they absorbed their authority into a trial level court. So we're the only one left with this kind of system. This past year, again, in this abbreviated legislative session, the bill to study the Orphans Courts passed the Judiciary Committee 14-1, and then it passed the House of Delegates 118-14, an overwhelming bipartisan majority to at least take a look at our current system and see whether any reforms are required. And again, as you know, there are 3 jurisdictions with attorney judges who sit one at a time, who have staff support, full-time paid staff support. 2 use our circuit courts and have been doing that for a very long time. And our remaining 19 jurisdictions have no staff. It's a mix of attorneys and lay judges, and some are all lay courts. It also seems to me sort of inevitable that this issue is going to be addressed by the legislature as they are moving, I think, very clearly in the direction of ending contested judicial elections for circuit court judges. I know here in Howard County, we're going to have a very hotly contested general election for an appointed judge. And I don't know how it's going to turn out, but he might lose, and there may be others who do too. So this is something that if we have only retention elections for Court of Appeals judges, Court of Special Appeals judges, circuit court judges, a defined 10-year tenure for district court judges appointed by the governor, I can't imagine that we would continue to have contested, partisan, 4-year term elections for circuit court, for orphans courts statewide. It seems like the next logical step that they would at least address the issue of whether they're elected. So that I think is definitely on the horizon. Next slide, please. And just to give some perspective on this issue, because the Orphans Court judges have offered lots of arguments, and I don't necessarily have a position one way or another what every jurisdiction should do, but the total cost for operating the Orphans Courts in Maryland is just over $1 million. And the percentage of estates requiring judicial action ranges from as much as 33% in Carroll and Prince George's to 18.5% here in Howard County, with a statewide average of 28.4%. So it's over 70% of our estates that are handled exclusively administratively. And one of the things that I've heard from a number of the judges that if we were to adopt the Montgomery County and Harford County model, where they have a circuit court judge sit as the Orphans Court, that the circuit courts couldn't possibly deal with the caseload that the Orphans Courts deal with. And I think that the statistics bear out that that's not really true. The circuit court caseloads would increase by as much as 11% in Somerset County to as little as 1.9% in Howard. So with a statewide increase of just under 4%. So while I'm obviously concerned about, additional caseload for the circuit courts, here in Howard County, we have 5 circuit court judges. We're close to getting a 6th, and we have 3 magistrates. If a magistrate can hear a case on uncontested divorce, or can even incarcerate people, I don't see why they can't handle a $1,000 attorney fee petition or sign off on a petition to probate a copy of a will. So a lot of these things, as you all know, are fairly routine matters. We're not talking about murder trials. Typically, we're talking about pretty standard administrative work. So I just wanted to provide those numbers to put that issue in perspective. And the last thing that I want to talk about before I guess we get to questions, if we get to the next slide, which is continuing allowing for E Filings and a new system that the registers are developing. I have received very positive feedback from attorneys and from the public about being able to file things by email. I want to look at continuing this practice, and that would obviously require a change to estates and trust and the rules. We are in the beginning stages of reimagining our internal case management system with an eye toward some kind of e-filing option, at least for attorneys. As you know, the vast majority of estates that we open are pro se, and it might not make sense to create an e-filing system that the public would have to wrap their heads around and master, which they probably will never have to use again. So we're looking at that. But in the short term, I really hope that we can convince the legislature and the Rules Committee to allow us to continue to accept e-filings by email and by fax. So I know I went through quite a bit there, but I was trying to get through all of this and with enough time to answer all of your questions. So again, we're working on a lot of things. Some of these things are pretty, they might come across as, fundamental changes to the system because, our nominal bond requirement and our publication requirement that's how it's always been. But, when we look at the benefit versus the cost of these things, I think that in my view, my conclusion is quite clear that we should be moving in the direction of removing these requirements and streamlining this process, reducing costs and time for us, for you, and for the public. So with that, those are all the comments that I had as part of my presentation. Again, if you have any, I think you all have a copy of my presentation, but feel free to call anytime or email me directly. I'm happy to talk to you about any of this or any other issues going forward, either what I've talked about here or other thoughts you have about our operations, the Orphans Courts, whatever it may be. Always eager to hear feedback from our Estates and Trust Bar. So thank you.
Thank you so much, Register McFarland. And it looks like we do have a couple questions. So let's see, I'll read those out to you. So the first one I have is, if you reopen an estate for a small income tax refund, for example, less than $500, do you have to pay the entire $300 filing fee again and go through the whole estate filing process as with the initial estate filing?
I think the answer is no, as long as it's the same PR.
Okay, and then we have another question. For the publication requirement, do you know of any other jurisdiction that does not require publication in a local newspaper? I'm wondering if there is a sample statute from a different state that Maryland could adopt.
Yeah, I don't know if there is another state that doesn't require a publication. I do know we did some research. Jumping back to nominal bonds, my staff and I looked at the probate process in over 20 other states, and none of them required nominal bonds if the will waive bond or the heirs waive. So we are out there in no man's land, either by ourselves or with very few other states that do what we do with bonds. So we are really an outlier when it comes to that issue. I know that Pennsylvania actually attempted a couple of years ago. They had it was like an omnibus. It was going to be like an omnibus bill that would create like a legal notice portal through the state judiciary or through the state. So all legal notices, foreclosures, death notices, I don't know what else would be in there, but anything that you could think of that would be a legal notice would all fall into this one system. And it didn't go anywhere. But, I know this is a flip side of this, which is our publishers, and I'm a big supporter of our free press. But this is part of their business. This is part of how they, generate revenue. And I'm not insensitive to that. But I don't know if there's any other state that has no publication requirement this time. But we do have that proposed legislation from Pennsylvania that could be a model. And one other thing I'll say is that, I think that in Maryland, I think it was this past year, as a matter of fact, that the old time requirement that name changes go into the newspaper. I think that the legislature, I don't know if they passed it. It's certainly something that I know the LGBTQ bar and advocacy groups were pushing because of potential risks to transgender Marylanders who are changing their name from male to female or vice versa. I think we may have passed that. So, we may be in a piecemeal approach, either because there's no point to it or because we have a usable, functional, beneficial online tool for free, in this case provided by us, kind of moving away from all of these publication requirements.
Okay, Register McFarland, I think that is all our questions today. Thank you so much for your time today.
Yeah, thank you. And again, if anyone wants to follow up on any of these, they didn't want to talk necessarily as part of the group, really happy to hear from anyone who'd like to chime in.
Excellent, thank you. And so everybody, that ends our presentation today. I did want to mention Micah and I are going to be planning out the next season of presenters. So if anybody has any ideas for topics, if you would like to present, or if you've heard someone else present that would be a great addition to the study group, please send Micah and I our email. We would appreciate that. And Register McFarland, thank you for ending our season on a high note. We appreciate your guidance and wisdom here.
All right, thank you all very much. I appreciate the time.
Thank you.